understanding of the Department of Labor was in was when there's a negative finding in a case, they automatically do it over. When there's a conflict, they automatically do it over with a different group to make sure the decisions are consistent, not arbitrary and capricious.
Certainly in the case of an equity court, you hope something like that would be a plausible opportunity.
Why is it we shouldn't actually hold our guardians ad litem to the same standard we do our employees and our employers?
Does anybody else need to be persuaded that this could be added? All right, Representative Willett is being recognized for a motion.
You know,
Let me express it. I'll express it.
no, I'm just saying, I was gonna move to pass this. There's so many additions, I don't know what I'm passing.
No, I'll tell you what we have so you know, and then you can decide if you actually still want to make the recommendation. The motion's already in motion. Otherwise, go out and find an officer. She knows what we're doing, so she's probably looking for another vote too. So let me
Bring in all that are available. Let's fill the seats. We have how many seats on this committee?
Representative, for the purpose of Representative Willett, I'm going to tell you what I understand our adjustments are to this. If he was about to make a motion that we go ahead and pass this bill, we would have changed, but with these exceptions, with these additions. There are a couple of grammatical things that need to be adjusted through the middle of this, nothing significant, and I know what those notes are, and I'm not going to explain them, but they were just a line here, two or three of them, not many. We're going to strike the phrase, fail to produce the mandatory report demanded by Family Division Administrative Court, and just reduce that one complaint to the mandatory stipulations for fee and services because we couldn't put those.
Where are you at?
At line 9, at 9 from the bottom, 1, 2, 3, 4, 5, 6, 7, 8, 9 from the bottom. So additionally, the clear finds that Ms. Hamilton A failed to produce the mandatory stipulations for fees and services alone. That would be the only thing, so striking that one line. The next one going down is C, not being stricken now, but being changed to oh boy, I was all clear when I was striking. Word for was that? No, that was your. No, that was the motion. That was an adjustment. What was that? Do you remember? Would you mind looking at your paper, Mr. Randall? What's this for you? We can get
That Ms. Hamilton's actions, while I forget what you put down, wrongful and improper, and would warrant potential criminal prosecution.
That's right.
Under these things.
Right.
Is
were it not for immunity is the phrase.
Were it not for the,
so we're going to use the basic concept and say, were it not for immunity, these would have been properly actionable. So
right.
It would, I'll rephrase that. That's all that will say. Everybody have that point made. Okay. In my phrasing, I put a dot on my eye so I know it's immunity. So 3 other words. Yes. Great. No, go ahead. But he has to be here for the motion. All right. So the recommendations. On the recommendations section, we're striking 2. Go down to line 7, we're striking 2. And then we're going to the next line, which will be the new 2, is going to say introduce legislation. That rules of evidence, rules of procedure, just as it says there, to be made statutory, and I'm going to have to phrase that, but that's what the phrase is going to be. I'm going to find a phrase that says that these are made statutory. All right? So I think we all agreed on that. And requiring that all motions of the petitions brought before authority not to vote. I'm sorry. The next one is just eliminating, about now again, 8 from the bottom, is the word recent. Right in the middle, it says the big word on the left will say GAL, audit hearing to be included in their recent report. And I would consider writing 2012 in there, but recent was going to be struck, but I think you said we probably better keep it so we know which report to put it in. So I'll put the date in there. It's a 2012 report. And then George's addition is all that's left. Representative Lambert's, I apologize, sir.
Well, you can call me George anytime.
I have to buy a lunch sometime.
No, you
Okay.
don't.
But, yeah,
Hey,
so
I let Laura
provision-
Haney call me George, I mean, come on.
So it's
If that has no meaning for you, I
provision
apologize,
G,
ask me in the hall.
in the end is at lunch, and provision G would be that, it would be phrasing, which I'll have to work on, to provide a single opportunity for each parent to reject a GAL. And.
Or the recommendations of a GAL.
To recommend what?
Actually, to request removal of a GAL. Is
Request removal is a
really
better
the
phrase.
appropriate.
That's the right word, yeah, request removal. Now, to request removal, we can probably already request removal, and won't get it.
Correct, I have a decision to that effect
No,
of
no,
taking
so
pictures
what you
of
don't
her
really mean is to request removal, but you mean to allow.
to demand removal.
To allow a demand removal to take place, so I can phrase that. We all know what we can, I'll phrase that, you know, properly. All right? That's what we're voting on. As soon as we have 10 people back in the room, we'll be ready to go.
At the end of E, you need to take the word "and" out.
Yes, I did. Thank you. Thank you. I did. I overlooked that. Yes, in close divorce custody matters, that mandatory appeals must be provided. And the word "and" is, and that's 4 lines up, right there. The word divorce custody matters, the word "and" goes away, and the letter F with that. So technically, George is going to be F, not G. Sorry,
See,
George.
I thought it was gonna be a recommendation named after me.
It is.
Yes.
For the Lambert Act.
No, that's, we're on a standing order.
I was trying to be cute, trying to like fill in while we wait for people.
I have to, before we go, don't anybody leave after this motion is made, because I need to make a statement, an important statement for you in terms of getting mileage today. Okay, just stay with us for a second. So, the motion, I recognize,
I move we accept this report as amended.
I second it.
all right. Any further discussion? Then, would you please, would the clerk stand in? Representative Hayward, please call the roll, and beginning with Representative Willett.
Representative Willett.
Yay.
Representative Hayward, yay. Representative Lambert.
Yay.
Representative Keyes, Representative Corrigan.
Are we voting on the amendment or
The whole amendment, the whole thing has amended that way, I just described it.
Oh, no.
Representative Baldessaro.
Yeah, for the record, of course, I have not sat in on any of this here, but I'm very familiar with the Vandenberg case, and I want to be on the yay.
You're the longest year I've heard this year.
I just want to make sure, clarify for everybody here.
D. Hogan sitting in for Susan Emerson, or?
Yes.
I'm sorry, Representative.
No, call all the regulars first and then go to the standings.
I did.
You call yourself?
I
you
did.
Call Willett, call-
Yeah, I did. I already called him Lambert. Yeah, Representative Kapler.
Yes.
How do you spell your last name, Petrie?
P-I-T-R-E.
P-I-T-R. Representative Petrie.
Yes.
Parson.
P-A-R-S-O-N-S.
Yay. Yay. Do I have everybody?
Yes.
You have Hogan already.
Ingridson.
Who?
Yeah.
Do they have another one?
Yes, sir. Do we have 10?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Yeah.
Okay,
Did you announce the vote?
10 to 1 is the vote in favor of finding 10.
Nine to
9 to 1.
Thank you folks very much. I'm going to close this and then tell you that we have, everyone must sign this paper. This is where you sign, unless you want to go next door and sign, but you can sign this also, but you can sign this only exclusively in my committee today. And not have to go next door.
Who gets this stack of paperwork?
Just send you back.
Oh, you have, that's right, you have to actually sign a affidavit over there.
I just signed that.
That comes up.